The judgment raises the constitutional question as to who has the taxing power to charge VAT in the country. Okay, from the submissions of the lawyers to the Rivers State government and the judgment itself, the position was that to the extent that VAT is not specifically mentioned in the Constitution, that the federal government lacks legislative power to enact the VAT Act or to collect VAT. Now, from a review of the Constitution, that's correct. However, that's not the point. The purpose of the Constitution is not to list all the taxes that a government can legislate on. All that is needed is a general provision under which any tax legislation can be subsumed. Okay, so if you read at articles, items 58 and 59 of the Constitution. Item 58 is on stamp duties, while item 59 is on income, and also on capital gains. Okay, vesting the power to legislate on the federal government. Now, on that basis, withholding tax is a subset of income tax. It's a tax that is deducted from payment for services or for supply of goods. And the vendor is entitled to withholding tax credit note from the tax authority. And that withholding tax credit is to be applied against its final income tax. So it's an advance payment of income tax, and therefore can be subsumed under Item 59 of the exclusive legislative list. Now, the judgment also referenced technology tax, which is a tax imposed by virtue of National Information Technology Development Agency Act. And that requires affected companies that are listed there, like financial services businesses, telecommunications companies, GSM companies, pension fund administrators, and on and on. Now, it requires 1% of the profit before tax of a company to be assessed and paid as needs that levy to the FRS. Now, the tax base for the technology tax is the income of a company, the profit before tax of a company. So it relates to income that Item 59 of the Constitution mentioned. Then also, education tax, tertiary education tax, is assessed at 2% of the assessable profits of a company. So again, that relates to the income of a company and the ancillary income tax liabilities of taxpayers in Nigeria. So to that extent, they are not separate categories of taxes that could be said not to be covered within the legislative power of the federal government in the Constitution. So I think that area therefore needs to be looked into by the Court of Appeal in order to ensure that there's clarity in that situation. Now, coming to VAT, it is true that it's not clearly mentioned, but like I mentioned earlier on, it's not every tax that the government is going to impose that must be specifically mentioned. Otherwise, every time a new tax is going to be introduced, then we have to amend the Constitution. Whether it's plastic tax, as some people had proposed, or sugar tax, or luxury tax. No, but that's not the way the Constitution is meant to be. The Constitution is meant to provide the framework for the taxing powers of the federal government and the state government and a local government as applicable. Now, in that judgment, the judge said, okay, in the absence of reference to VAT in the Constitution, then it means that the federal government could not enact VAT Act and therefore should not collect VAT Act in the states. Now, the question is, if VAT is not specifically mentioned in the exclusive legislative list and the concurrent legislative list, where are the states also deriving their power? Now, normally, if an item is not specifically mentioned in the exclusive legislative and concurrent legislative list, it means that it will be in the residual list and states can enact legislation on it. However, to me, VAT is such a significant item that should not be left to the residual legislative power of the cost of the states within the country. If you read item 62 of the Constitution, it gives power to the federal government to legislate on trade and commerce. VAT is a tax on trade and commerce. And it mentions specifically there that the federal government will have legislative power on interstate commerce and also international trade and commerce. So in other words, importation of goods into the country and other international transactions. So assuming therefore, you want to agree with the states that federal government does not have power to legislate on trade and commerce within their states, that could be correct. However, the federal government has power to legislate on inter-trade commerce. In other words, when goods move from one state to another, okay, the VAT there should legitimately be charged by the federal government. And then VAT charged on import duties into the country, because it's customs that's the agent of the federal government that collects it. So I don't think that's an area, for instance, that states can legislate upon. So at the end of the day, therefore, it's about really delineating the legislative power of constituting entities within the federation. In what areas can the federal government impose VAT? And in what areas can states impose VAT? States only have jurisdiction on activities within their state, but federal government has legislative power over activities across the federation. So in therefore reforming the VAT system in the country, that needs to be taken into consideration. However, it will be interesting to know how the Court of Appeal is going to resolve the matter, to bring clarity, to the confusion that has been caused, by the judgment. Well, if states they have done wanted to exercise their legislative powers on the basis of that judgment, I thought it was something that actually they should have given sober consideration to. Okay, enacting the law just a few days after the judgment, I think the time was too short to make any reasonable stakeholder consultation. One of the states, for instance, invited the public to the public hearing on the bill. But then it was the second day after that public hearing that the bill was enacted into law. So, meaning that whatever input that stakeholders provided could not have been factored into the legislation. So in other words, the bill was enacted as drafted. And that would really cause a lot of operational issues. For instance, the provisions of the state VAT law did not address how input VAT is going to be recovered from output VAT, particularly in interstate commerce. Okay, some of the states wanted to charge VAT on import duties, but the question is, how are they going to be collecting the VAT on import duties when customs is an agent of the federal government and it's customs that collects the VAT? Again, the exemption list provided is rather lean. It's not as broad as the one granted in the VAT Act. So again, also under the VAT Act, small businesses with a turnover of less than 25 million are exempted from VAT. But the state laws did not make any reference, to that threshold, meaning that small businesses that were exempted under the VAT Act now have to be paying state VAT. Again, there's a dichotomy between the rate of VAT charged by the federal government under the VAT Act and the rate, for example, prescribed in the Lagos State VAT law. And the question is, okay, now if you pay input VAT, say at 7.5%, now you can only offset it against output VAT of 6%. So to me, these are matters that actually should have been given thoughtful consideration and enough time to really digest the issues involved in state VAT law, because there are nuances that are actually peculiar to state collection of VAT, separate from the peculiarities of VAT administered as a federal legislation or tax. My view really is that VAT administration is quite different from the administration of other taxes. Okay, it's not like sisters that you just collect and that's the end of it, because there will be instances where you have to allow input VAT recovery from the output VAT. FRS as they've had 28 years experience since 1993 when the law was enacted, and implementation actually started in 1994, just to allow them to be prepared, because you need to set up the infrastructure, for this. So I won't say that any state in particular already has the capacity to administer VAT. They will have to invest in the infrastructure for this. And the question is, even if we decide at the end of the day that every state can collect VAT, it's not efficient for every state to be setting up infrastructure for collection of VAT, because all it means therefore is that they'll be replicating the capital cost of the infrastructure, they'll be replicating the operating cost of collection of VAT, and at the end of the day, it's not going to be efficient. So we already have a VAT administration system that is working, that the FRS is in charge of. And I would say that in the event that states are empowered legislatively to begin to collect VAT within their states, they could still use the FRS as agent for collection and pay FRS a fee as cost of collection. And that would really be efficient, it would be seamless, and then it can address all the issues relating to recovery of input VAT from output VAT, because now you have one central agency that is collecting both on intrastate commerce and also interstate commerce. So that's the way I will say that the VAT collection system should be designed, going forward, in the event that states are empowered, to collect VAT. If in the end, states begin to exercise their powers to collect VAT, it means that what will be changing is the collector, moving from the federal government to the state government. Again, rates could vary, just as we've seen in Lagos State, where Lagos State VAT rate is 6% and federal is 7.5%. However, if the federal government also enacts a legislation, vesting with rights to collect VAT on interstate commerce, what that could also mean is that the collection power, for VAT, will be split between the state and the federal government. And again, a federal government may decide to retain its own 7.5% rate, meaning that for those who will be liable to VAT rate for interstate commerce, the rate will be 7.5%. So if, for instance, goods are transported from Lagos to River State, for sale there, the federal government will be responsible for, charging the VAT, because that's interstate commerce, and that could be 7.5%. But Lagos State, will be 6%. So you will experience that dichotomy, and it will really cause confusion in the minds of taxpayers. Just as in the last few days, people have been bewildered, at what was going on in the fiscal landscape in Nigeria. So again, what also happens is that if you are a business that's operating in different states of the federation, you then need to again have a system in place for compliance in every state, and then be able to also isolate the VAT due to one state, to another. Again, that can increase your cost of compliance, for tax in Nigeria, and it will affect the ease of doing business in the country. It will send conflicting signals, and not just international community, even investors that are currently in the country, and also taxpayers within the country. It sends conflicting signals about the fiscal system in the country, and also it gives the impression, that really we are confused as to how tax will be administered in our country, because no taxpayer will enjoy being caught, between the rock and the hard ground, which is exactly the situation we are in now. No taxpayer would like to be the grass, that suffers when two elephants are fighting, and that's why it's important for this crisis to be resolved, sooner than later, so that there's clarity as to where we are going as a country. they are destroying alcohol, I mean, all it means is that sale of alcohol in the state violates the state law, meaning that there must be a law that prohibits sale of alcohol. So that's why, they are doing that. And also, if businesses comply with that law and they don't sell alcohol in the state, right, it means that no VAT will be collected. Okay, so that's their faith in expression, and that's the way I would see that. Now, if you then review the provision of the VAT Act, Section 40, that defines the sharing ratio, that federal government will collect 15%, states will collect 50%, and local governments will collect 35%. Now, that gives statutory rights to all the states of the federation to share in that 50% allocated to the states. Okay? And that did not make a distinction between states where alcohol is consumed and permitted and states where it's prohibited. So it's the entitlement of all the states of the federation to have a share in that. Now, again, how much really is the amount of VAT collected on alcoholic products in the country? I think it's just about 3%. So really, it's not a significant amount of tax. And to me, when states begin to raise this point, it's just an indication of their dissatisfaction with the status quo in terms of how VAT is shared. If the government could address the derivation principle and ensure that there's equitable reallocation of VAT to states based on their contribution to the national pool, I believe this issue will go away. Currently, under the VAT Act, only 20% of VAT collected amongst the states and local governments are shared on the basis of derivation. Only 20%, and really, that's not quite fair to the states that contribute a lot to the pool. There should be a sharing pro rata. And as a matter of fact, if we have a federal and a state VAT system, ordinarily, states where VAT is collected on intrastate commerce should be able to retain the VAT collected 100%, subject to paying collection fee, to the FRS, if FRS is retained by the state to administer the tax for them. So there is logic in the argument made by the states, that are saying that, look, let the sharing be based on the basis of contribution, on the basis of a derivation, in order to ensure that they are compensated fairly for contributing to a larger proportion to the pool. Lagos State, for instance, contributes over 50% of the VAT collected throughout the federation. Now, if you are then saying, okay, they will only be entitled to a derivation in terms of 20% of the VAT collected, I don't think that is quite fair. And that's why at the end of the day, really, the way out of the present imbroglio is through political negotiation. Okay, if the federal government can address the sharing formula and ensure that there's a higher proportion attributed to derivation, then I believe that this crisis will go away. So the complaints against states that are destroying alcohol, really, to me, it's like a symptom, but it's not the real issue. The real issue is about making the derivation sharing formula more equitable, rather than what it currently is, where states that collect more do not collect as much back by the time the VAT revenue is distributed among the states and the local governments. I would say that they can use the platform of the National Economic Council to actually discuss and negotiate the resolution of this dispute. Okay, I think the states that say that they contribute more but then get less, they have made their point loud and clear. Okay, and there should be fairness and equity as to how the VAT collected, should be distributed amongst the states. So they should go, to the negotiation table and work out an acceptable formula for sharing the VAT, recognizing the contribution made by each state, to the pool. So rather than 20% being shared on the basis of derivation, they can increase that percentage. Or again, states that collect the VAT can retain VAT within their state. At the end of this, it's about efficiency in collection. Trade and commerce goes on in every state of the federation, but it's not about, it's the volume that is different. And what it also means is that, a state like Lagos State, where the largest chunk of the VAT is collected, also has significant cost to incur before they can support businesses operating within the state. In states that have less economic activities, all it also means that they need less infrastructure to support businesses within the state. So at the end of the day, I think, there'll be equity, if that is done. But it's a matter that should be negotiated politically and resolved. Businesses are organized properly in the country, I would say, because there are chambers of commerce, and then there are umbrella organizations like Nigerian Employer Consultative Association. There are sector-based business groups, and all of that. So in a matter like this, they can't sit by. They need to make a contribution to the debate. Because at the end of the day, a tax system must be fair and it must be equitable. There must also be certainty, which you don't currently have. And also, there must be tax. It must also be convenient for them to be able to pay their taxes. And also, the cost of compliance must not be excessive. So, to me, these are areas that should be of concern to businesses. And therefore, as stakeholders in the fiscal system, they need to make their contribution, to this. And I will expect that before we launch another round of a comprehensive reform of the VAT system, that there will be stakeholder engagement to provide a forum for businesses to make their contribution, either on company basis or better still, as industry or sector-based organizations. And I will expect that before we launch another round of a comprehensive reform of the VAT system, that there will be stakeholder engagement to provide a forum for businesses to make their contribution, either on company basis or better still, as industry or sector-based organizations.
Okay, so my last question, I am sure and I believe that you have experience as to how the tax system works in other places. Developed countries now. How does it work in other places? Or which country do you think, okay, in resolving this impasse, which country should we look, to, in terms of how they've been able to, have a proper tax system? Okay.
Well, first, tax is country specific, and there's no one size fits all. Every country designs their tax system in a way that they feel suits them. So for instance, in the US, state tax is a state tax. Okay, federal government doesn't get involved at all. And the only controversy within the US with respect to sales taxes, with respect to interstate commerce. Okay, particularly when a business that is not resident in a state is selling business online to another state. Okay, so there's a case in the US in 2017, South Dakota State versus Wayfair Inc. Okay, where that matter was resolved by the US Supreme Court to say that even if you are not selling goods physically within a state, you don't have a physical establishment within a state. If you are delivering goods or services in another state, you should pay the VAT of that receiving state. And that has been resolved, with respect to the US. And those are some of the cases that we actually need to study as we begin to fashion a new VAT system, for the country, that we have to address the peculiarities and uniqueness of interstate commerce. in order to avoid conflict between one state or the other, because everyone would like to grab as much VAT as possible. Now, if you go to India, India is also a federation, like Nigeria. And in 2016, they introduced goods and services tax, under which the federal taxes interstate commerce. And then for interstate commerce, there's a federal element of it, and there's also the state element of it. That's the way they have resolved their own. And implementing such law is not without challenges, because since then too, they've had to also look into how to reform the system in order to avoid interstate conflicts and also conflicts between taxpayers and the states. Okay. Now, if you go to Canada, practically all the states, I think except Alberta, also has a sales tax system. So they don't have a VAT system, but a sales tax that they implement. And there's also a federal sales tax as well, which is then again shared under their own arrangement for fiscal and revenue allocation amongst the states. So every country does what suits them, depending on their the structure of their government. If you go to Ghana, Ghana is a unitary system of government. So this kind of dispute will not arise, because the central government, collects the VAT and then administers it like any other revenue that it collects. So we have to design a system that works for us, leveraging the experience of other countries which are organized as Nigeria. Well, I would say it's an interesting times, as challenging as it is, and the crisis gives us an opportunity to actually properly enforce fiscal federalism in the country. Okay, the truth is that we are not in a military regime where the federal government legislates for everybody, and then will not care a hoot, what anybody feels. No. We run a federation, and fiscal federalism needs to be practiced to align with the federal system of governance within the country. So federal will know the limits of its powers as a tax collector. State governments and local governments also know the limits of their powers in order to again ensure that there is harmony within the fiscal system in the country. So I would say, by way of last word, let's practice fiscal federalism in all its tenets.